There's a thing you learn as an adult that nobody sits you down and explains. Most of the rules holding your life together aren't enforced. They're just agreed to. Nobody stops you from parking in the fire lane. There's no gate. There's a painted line and a shared understanding that the line means something. The system runs on almost everybody agreeing not to test it. Government works the same way, and we call that agreement norms. Not laws, norms. And when people say norms are eroding, it sounds soft, like manners, like somebody didn't send a thank you note. So I went looking for the version you can count. Start in Minnesota. In late 2025 into 2026, the administration ran a large immigration enforcement surge there. Thousands of federal agents, thousands of arrests. And people did the thing you're supposed to do. They sued. They went to court. Judges heard them, and judges issued orders. Release this person. Hold a bond hearing within 7 days. Normal judicial function. Then the orders didn't get followed. Not once, repeatedly. So the chief judge of the federal district court in Minnesota, Patrick Schultz, did something judges basically never do. He started counting. On January 28, 2026, he attached an appendix to a court order, a list, 96 court orders that ICE had violated across 74 separate cases in one district in about a month. He added the real number was almost certainly higher and noted the list was put together in a hurry by judges who were drowning. His line was, ICE has likely violated more court orders in January 2026 than some federal agencies have violated in their entire existence. Now, before anyone decides where this is going, Schultz was appointed by George W. Bush. He clerked for Scalia. This is not a liberal firebrand. This is a conservative judge counting. And here's the part that tells you what norms actually are. The government pushed back. Minnesota's U.S. attorney emailed the judge directly to complain that the count was, in his words, far beyond the pale of accuracy. He said his office had reviewed what he called a statistically strong sample, 12 cases, and found high compliance. So Schultz had his clerks go verify every single case, all of them. And when he came back in late February, his findings held. He also pointed out that the U.S. attorney's statistically strong sample was just the first 12 entries on the list, in order. Then he updated the tally, another 100 plus violations, most of them after the government had promised to do better. His response to being told he was beyond the pale? If anything is beyond the pale, it's ICE's continued violation of this court's orders. And he said he'd move to criminal contempt if he had to, which can mean jail. And this is not just Minnesota. By spring 2026, the Washington Post reported the administration had been found in violation of court rulings in an extraordinary number of cases, across a wide range of issues. Separately, a federal judge in Washington found probable cause for criminal contempt over deportation flights that didn't turn around after he ordered them to. An appeals court threw that finding out, though it let him keep investigating. So let me be straight about the limits here, because they matter. Some of these findings got reversed on appeal. The government disputes the counts, and a court saying you violated an order is not the same as a final ruling that you did. That's what appeals are for. If you want to hand this to someone who will argue with you, hand them Schultz's actual order. It's public. It has the appendix attached. But I want you to notice what the fight was even about. Nobody in this story is arguing that court orders don't have to be followed. The government's position was never, we don't have to. It was, your count is wrong. Everyone is still performing the agreement. They're just also not doing the thing. That's what erosion is. It isn't a coup. Nobody announces it. There's no moment where the judge is arrested and the courts close. The orders keep getting issued. The judges keep ruling. The paperwork is immaculate. The only thing that changes is what happens after. Because a court order was never a physical object. It cannot open a cell. It has no arms. It is a piece of paper that works because everyone downstream of it has always agreed to act as if it works. Take away that agreement, and you haven't repealed anything. You've just revealed that the fire lane was always paint. I keep coming back to the detail about the sample of 12, not because it's the worst thing in the story, because of how ordinary it is. Somebody checked the first 12 items on a list, stopped, called it statistically strong, and sent an email calling a federal judge inaccurate. That's not a villain. That's a guy who didn't scroll down. That's most of how this works.